So you may have heard about this already, but a new George Carlin comedy special recently came out. That's a little bit strange because George Carlin has been dead since 2008. So how did they do this? Through the magic of AI. The creators of a large language model AI called Dudesy trained the AI using thousands of hours of various George Carlin comedy bits and had Dudesy write the script for the comedy special. The Dudesy AI also simulated George Carlin's voice to read the script for the special. A company that owns the rights to all of George Carlin's intellectual property, including his comedy bits, is now suing the creators of the AI for copyright infringement and misappropriation of Carlin's name and likeness. What do I think about the merits of this lawsuit and its impact on the use of AI in independent films? That's what we're going to talk about in this video. Now, before I get into this, one thing that I should note is that after the lawsuit was filed, the creators of Dudesy and of the George Carlin AI special came out and said, no, this actually wasn't an AI, and it was actually written by one of the hosts of this podcast that features Dudesy on it. But the lawsuit is still in its very early stages, and we haven't really established, or the evidence hasn't really established whether that's true yet. So I guess we shall see. But assuming that it was generated by an AI, as the complaint in this case alleges, let's talk about what the legal implications of that are. But first, as usual, a couple of disclaimers. First, what I'm going to be telling you is not legal advice, because if I were going to be giving you legal advice, I would need to understand your specific situation and your specific needs, and right now I'm just a random lawyer talking to you on the internet. Second, we're going to be talking about matters of U.S. law, specifically U.S. copyright law and some state law about misappropriation of name and likeness. So if you're making your indie film or you're operating outside the United States, then the legal concepts that we talk about in this video might not apply to you. Also, if you found this video helpful, please like this video and subscribe to this channel so I can keep providing this kind of informational content to young, hungry, up-and-coming independent filmmakers like yourself. So, getting back to the question at hand, did the Dudesy creators do anything illegal by creating this AI George Carlin special? For copyright purposes, I think that the first question that we need to ask is whether the mere fact that the creators trained an AI using George Carlin's material amounts to copyright infringement. This is a legal theory that we've heard in other cases filed recently against the developers of ChatGPT and other large language model AIs. Without going into too many technical details, the process of training an AI does involve making digital copies of the training material. In this case, the George Carlin stand-up routines that were used to train the Dudesy AI. So there was copying involved in the creation of this comedy special. But according to the state of the law right now, which admittedly is in the early stages of its evolution, the mere fact that the defendants, that is, the people being sued, copied George Carlin's material to train the AI doesn't mean by itself that they infringed the plaintiff's copyright. Instead, to be infringing, the fake AI comedy special needs to be, to use the legal jargon, substantially similar to George Carlin's actual comedy routines. The lawsuit by Sarah Silverman and others against OpenAI, the maker of ChatGPT, illustrates this point. In that case, the plaintiffs claimed that because OpenAI trained ChatGPT using their copyrighted books, every output by ChatGPT, that is, every answer it gave to a user's question, was in some sense a copyright infringement. The judge disagreed with that argument and said, no, the mere fact that ChatGPT was trained using Sarah Silverman's or someone else's book doesn't mean that every answer given by ChatGPT infringes Silverman's copyright, because the plaintiffs didn't show that any answer by ChatGPT was in any way similar to Sarah Silverman's book. Now, is the AI comedy special similar enough to George Carlin's actual work to infringe the plaintiff's copyrights? Well, the complaint, that is the legal document that describes the claims being made by the owners of Carlin's IP, doesn't really get into that issue. And that's understandable in a sense because it's not always easy to prove substantial similarity in copyright cases. If you were trying to figure out, for example, whether two novels were substantially similar for copyright infringement purposes, you'd have to compare many aspects of those novels. You'd have to look at their dialogue, their characters, the structure of their plot, and so on. To do this comparison in the context of the AI comedy special that we're talking about here, you'd have to do this painstaking comparison between George Carlin's actual work and the script for the AI special. It's not clear from the complaint that the plaintiffs have done this analysis or that they intend to do it at all. That's one of the reasons I think the plaintiffs in this case are going to have difficulty making a viable copyright infringement claim. Another problem for the plaintiffs is this concept of fair use. Even assuming that the fake Carlin special is substantially similar to some actual copyrighted work by George Carlin, it's still possible that the fair use doctrine will prevent the plaintiffs from successfully making a copyright infringement claim. I've talked about fair use pretty extensively on this channel before, so I won't go into mind-numbing detail about it. But to be brief, there are four factors that courts look at in deciding whether someone's use of copyrighted material is fair use. And the two most important ones are, number one, whether the use is quote-unquote transformative. That is, that it puts the copyrighted material into a new context or interprets it in a novel sort of way. And two, whether the allegedly infringing use is likely to reduce the profitability of the copyrighted material. That is, whether consumers are likely to buy the infringing work instead of the copyrighted one. Is the fake Carlin special a quote-unquote transformative use of George Carlin's comedy routines? I think a pretty good case can be made that it is. The AI scripted routine, while I wouldn't say that it's super funny, does try to comment in the style of George Carlin about contemporary issues that didn't exist in Carlin's time, such as, ironically, the use of AI to impersonate celebrities. As for the effect on the market or the effect on profitability factor, will people watch the AI Carlin special instead of watching his actual comedy specials? I doubt it. The AI special is actually called I'm Glad I'm Dead, and the creators made clear in all the social media posts that they did about it that it was created by an AI that was trained to write material in the style of George Carlin. I don't think that your average consumer would be confused about whether George Carlin was responsible for the AI special and say, oh, I guess I've heard Carlin's 2024 material and I don't need to go into the back catalog. So I think there's a good case to be made that the AI George Carlin special amounts to a fair use of George Carlin's copyrighted material. Now let's look at this right of publicity issue, which is another legal concept that I've talked about on this channel. The state of California, briefly, has a statute that prohibits the use of a deceased person's name, likeness, and image for commercial purposes. It's fairly clear that the AI special does use Carlin's name and likeness. The creators identified the special as George Carlin's 2024 comedy special, after all, so they use his name, and they put an AI-generated picture of him in social media posts that promoted the special. But the California courts have made clear that, as with copyright law, there's a fair use defense to right of publicity claims, which depends on whether the use of the name and likeness is quote-unquote transformative. As I talked about, I think that the AI Carlin special's use of George Carlin's name and likeness could be considered transformative. And so the creators of the special have a pretty good shot at a fair use defense to this right of publicity claim. Another issue is that the owners of Carlin's IP would have to show that they were damaged in some way by the misappropriation of George Carlin's name and likeness. In other words, basically, were the IP owners deprived of profits that they otherwise would have made because of the release of the AI comedy special? Again, I suspect that the answer to that question is no. It's not as if the creators of the special hid the fact that what they released was not actually George Carlin, nor would they realistically have been able to do that, because it's a well-known fact that George Carlin has been dead for 16 years. So overall, I think that the plaintiffs in this case actually have a hard row to hoe, but we'll see what happens when the judge actually starts to examine their claims. So I hope this was helpful to you in understanding the current state of play in the litigation around how copyright law applies to AI, and thank you for watching.